Good afternoon, everyone. It's great to see you all. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Thursday, March 28th, 2024. The time is 1:30 p.m. With us today are Commissioner Bobby Ginecca and Commissioner Catarina Gonzalez, as well as our General Counsel, Mary Smith, and I'm John Neerman. Registration has now closed, but if you'd like to address the Commission on a particular item, please visit our registration table or email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate that request. For those who are addressing the Commission, our General Counsel or I will let you know when it is your turn and inform you of your time limit. I want to thank everybody for being present today. For those in the room, I want to congratulate you on finding the correct room and the correct time. This is not our normal meeting space. Let me also thank the Texas Workforce Commission for hosting us while our meeting room is under construction. With that, Ms. Smith, I think we're ready to call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application by the City of Liberty Hill for the renewal of TIPD's permit number WQ00144777001. Presentations will begin with the applicant, followed by the protestants collectively, the ED, and OPIC. The parties have been notified that they will each have 5 minutes of oral argument time, and the applicant may save time for rebuttal as it bears the burden of proof on the application. So that will begin with the applicant. I believe we have Ms. Natasha
Good
Martin.
afternoon, Ms. Martin.
Good afternoon.
Ever be able to achieve the limit, the unprecedented load limit. Provide a vital real world impact because the city's customers will not be able to reflect. This is a perspective, a big block bagging, inside bagging, filled with criminal here are the top provisions to reject the issue. 1, it is clearly physically impossible to reach the limit. 2, it seems to violate the law by setting the limit under the what is physically lab in the set. 3, regardless, what the size of the draft is protected. Number 1, no existing plan and completely 0.15 due to natural fluctuations in operatable behavior. There are basic constitutions in time. The author of this process is 0.015.
Does that help? Oh, that's way too loud. I'm going to stand back here. To reach 0.015, they need to be consistently hitting 0.009. That is impossible. And according to 3 expert witnesses, including TCEQ's witness, this low limit cannot be achieved by a plant that's already built. The evidence also states that a reverse osmosis plant would be needed to achieve this limit. Liberty Hill doesn't have a reverse osmosis plant. Reasonably achievable limits are factors to consider and are factors that can be the basis of a decision for meeting the Texas surface water quality standards. Despite this, and on a renewal, the PFD improperly forces Liberty Hill to redesign its brand new plant that was put in 2021 to construct another brand new plant to achieve limits that we don't even know are proven to protect the river. Number 2, the PFD would set a terrible precedent and violate a rule by imposing compliance below what any accredited lab can detect. TCEQ mandates that data submission to show compliance be sampled at an accredited lab. What we're told is that 0.05 is what these labs will certify. Now, you'll hear from the protestants that Baylor's lab, for example, could detect the limit in the PFD. However, Baylor's lab is not certified, and any exception to allow certification from a non-accredited lab would be reckless, because you're essentially allowing certification by an unvetted lab that's not vetted by TCEQ. Setting this limit below what an accredited lab can detect is statewide policy setting, and it's certainly not a policy that the TCEQ wishes to set here. And then third, I've got, well, I thought I had a PowerPoint that would be up, but that's okay. I've got pictures of the river. And so my co-counsel, Rudy Mater, can show you these photos, but essentially operating at limits under the current permit, we've got record images that show that the river can be aesthetically pleasing. You're going to hear from the protestants that the river is constantly covered in algae, is constantly not aesthetically pleasing. But here,
And Ms. Martin, to be
Yes.
clear, these images are part of the record in
they
this case?
are,
Okay.
they were
Thank you.
admitted in App R5, and as part of our operator's testimony. This image shows the river in December 2022 operating, let's see, at that day, the discharge concentration is 0.05.
That's 4 minutes.
Oh, thank you very much. Okay, and then also here, January 2023, the concentration was about 4 times what is in this PFD. And then also spring of 2023, we had discharge also about 5 times what's in, oh, that's so loud, the PFD. The 0.015 is unattainable, it's unrealistic. The judges were not living in the real world. They were living in a legal fiction. And you, the commission, do have to make decisions based in the real world. I'm going to reserve the balance of my time, except I'm going to say one more thing. We do ask for you to issue the draft permit at 0.15 for the reasons stated. And also, if not, if you have to send this back, it would be to establish a limit that can be measurable by an accredited lab. Thank you.
Thank you, Ms. Martin. Any questions for Ms. Martin? Seeing none, thank you. Let's hear next from, I think it's going to be Ms. Ice for the protestants.
Yes, good afternoon. And we also have some exhibits I'd like to set up before we get started.
So just to be very clear, we're not running the clock while the exhibits are being assembled.
Thank you. May I proceed?
Go ahead.
Thank you.
Yes, thank you.
Good afternoon, commissioners. My name is Lauren Ice, counsel for Stephanie Ryder Morris, one of the protestants in this matter. Ms. Morris is with us today, as is my co-counsel, David Frederick. Also in the audience are several of the members of the Bunnell protestant group who have graciously allowed us the full 5 minutes to present to you today for the protestants. And I want to start by addressing the scope of the remand hearing. The commission determined that the protestants already rebutted the prima facie determination that 0.15 milligrams per liter would meet the Texas surface water quality standards. Neither the city nor the ED had supported this limit at hearing, but rather than deny the amendment, the commission remanded this docket to SOA for all parties to present additional evidence to determine what total phosphorus limit is necessary to comply with those standards. And the protestants are the only parties who provided evidence responsive to commission's order on remand. The city and the ED again rely on the 2013 anti-degradation review that this commission previously rejected. And as a reminder, the burden of proof is on the city. So for this reason alone, the commission should adopt 0.015 milligrams per liter. On remand, our ALJs were guided by 2 important thresholds present in protestants' evidence. The first is the scientific tipping point identified by Dr. Ryan King, a research scientist at Baylor University, who concluded the tipping point for total phosphorus is 0.02 milligrams per liter. In other words, as phosphorus concentrations rise towards 0.02, the likelihood of algae blooms increases. And at 0.02, algae blooms are all but certain. The second important threshold is the point at which algae cover negatively affects public perception of a river, identified by Dr. Jan Stevenson, a research scientist recently retired from the University of Michigan. Dr. Stevenson identified 6 to 17% algae cover as the point when recreational desirability, or the river's approval rating, drops dramatically from over 90% to less than 30%. So Doctors King and Stevenson agreed when effluent reaches that 0.02 tipping point, it is not a matter of if, but a matter of when algal cover will exceed that 17% threshold. Now compare, if you will, the two photos on your left, which were taken by Ms. Morris, the top photo upstream of the city's outfall depicting baseline water quality conditions, and the bottom photo just below the city's outfall taken near the end of March last year. In the bottom photo, the city had been averaging 0.065 milligrams per liter total phosphorus for the prior 4 months in a row. This is less than half of what is proposed in the draft permit. To your right, the top photo was taken by Ms. Morris on April 22nd, 2023. This is below the outfall, and you may notice the river looks much cleaner, and this is because there was a large storm event that scoured the algae from the area just prior to this photo being taken. However, the bottom photo on your right was taken less than 2 weeks later, and it shows algae downstream of the outfall growing back at a rapid rate, even though the city's total phosphorus concentration was the same, 0.065 milligrams per liter. Based on these two thresholds and the rapid algae growth observed in the South San Gabriel, Drs. King and Stevenson concluded that 0.015 milligrams per liter is necessary to avoid excessive algae growth in this location. No experts for the city offered an opinion on this point, and the ED's aquatic biologist, Mr. Schaefer, would not himself defend 0.15 milligrams per liter, instead agreeing with Dr. King's tipping point. The city's arguments remain outside the scope of the remand order. They effectively admit that this plant never should have been built here in the first place. They continue to argue that 0.015 is not achievable, it's too costly, it will put the city out of compliance with its permit tomorrow. These arguments are flawed for 3 reasons. 1, under the Clean Water Act, it is not the Commission's mandate to permit a discharge because it is easy. It is not the Commission's mandate to permit it because it is easily available or readily available to the permittee. The Commission's mandate is to ensure the permit will not cause more than de minimis degradation of water quality. 2, we all understand there are practical challenges to achieving 0.015. But there are also practical solutions. They're in EPA guidance and they're in TCQ's rules. They include solutions like truck and haul, reuse, land application, even compliance schedules, and even an exception to the NELAP requirement that Ms. Martin was referring to earlier. 3, the city is already out of compliance with the water quality standards. As we've already discussed, they're violating the aesthetic standards, they're violating the requirement to maintain existing uses, and they're violating the requirement to avoid degradation beyond a de minimis amount. The question for this commission is not whether the city will be out of compliance tomorrow, but whether the permit that you issue is intended to achieve compliance.
That's time.
I'll just conclude with one last point, that these images, I will point out, show discharge at 1.75 million gallons per day. So without commission action, this permit will increase to 4 million gallons per day. And the problem is only going to get worse. So that is why we're asking you to set the limit at 0.015 milligrams per liter. Thank you.
Thank you, Ms. Ice. Colleagues, any questions? Seeing none, let's hear next from the Executive Director staff. Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. I'm Aubrey Puelka with the Environmental Law Division. With me today is Peter Schaefer with the Water Quality Division, Alfonso Martinez with Water Quality Division, Robert Sadler, Deputy Director of Water Quality Division, and Carrie Michelle Kyle, the Director of the Office of Water. The draft permit complies with all statutory and regulatory requirements, including the Texas Surface Water Quality Standards. A total phosphorus limit of 0.15 complies with agency procedures and our procedures to implement the Texas Surface Water Quality Standards. There are currently no TIPDs permits with an effluent limit below 0.15 mGLTP. This facility is currently authorized to operate at 0.5 total phosphorus. If the applicant complies with the terms of the permit, 0.15 total phosphorus is expected to prevent excessive algal growth that would impair the existing uses of the receiving water and is expected to prevent the degradation of water quality by more than a de minimis amount. The executive director respectfully recommends that the commission grant the application and issue the draft permit without changes. Thank you, and we are available for questions.
Thank you, Ms. Palka. I have no questions. Any questions? Seeing none, let's hear next from OPIC.
Good afternoon, good afternoon, Chairman, Commissioners, General Counsel, and the Executive Director's attorney and staff. I'm Pranjal Mehta for the Office of Public Interest Counsel. OPIC supports the administrative law judge's supplemental proposal for decision and the recommended revisions discussed by the ALJs after considering the parties' exceptions to the supplemental PFD. The issue during the remand hearing in this matter was to determine the total phosphorus effluent limit necessary to comply with the Texas Surface Water Quality Standards. OPIC agrees with the ALJ's findings that the TP effluent limit necessary to comply with the standards is 0.015 milligrams per liter. The evidentiary record includes compelling evidence that a TP effluent limit of 0.015 milligrams per liter would prevent the excessive algal growth that impairs the existing uses of the South Fork San Gabriel River. The record also includes expert testimony that a TP limit of 0.015 milligrams per liter would prevent lowering of water quality by more than a de minimis amount because biological changes to sensitive diatoms will begin at concentrations between 0.01 and 0.015 milligrams per liter of total phosphorus. Therefore, OPIC agrees with the ALJ's findings that a TP effluent limit of 0.015 milligrams per liter is necessary for the draft permit to comply with the standards and to prevent excessive algal growth that impairs existing and designated uses of the receiving water and to prevent the lowering of the water quality in the river by more than a de minimis amount. OPIC also agrees that applicant's evidence was insufficient to meet its burden of proof on the remanded question. Given that the plant is currently operating and serving the residents of Liberty Hill, OPIC recognizes that outright denial of the city's renewal application may not serve the public interest. Therefore, in lieu of denial, OPIC recommends amendment of the draft permit to include TP effluent limit of 0.015 milligrams per liter that is necessary for the draft permit to comply with the standards. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Mehta. I have none. Colleagues, any questions? All right, Ms. Martin. Protestants have about 30 seconds left.
Simply put, as you heard, the facts don't support what's happening here. The data doesn't support the facts here, and the people don't support the facts here. How do I know about the last part to it? Not only am I a representative of my client here in Liberty Hill, but I'm also a city council member of the city of Pflugerville. And when I speak to elected officials across this state about the standard that is offered, they are shocked and appalled about this. You have to be ready to retrofit every single wastewater treatment plant across the state of Texas and blow up your own
Mr.
rules
Metier,
to follow this.
we need to limit our remarks to what's in the administrative record, and I'd like to caution the commissioners that this information was not in the administrative record.
So again, I'll reiterate, the facts, the data, the science do not support
That's time.
anything with that. Thank you.
Thank you, sir. All right, colleagues. I am very interested in your thoughts on this item, but I'll go first, at least partway. And here's my take. The applicant does indeed bear the burden of proving that the draft permit meets Texas's surface water quality standards. And as it relates to total phosphorus, the standards prohibit discharges that impair the use of receiving waters by causing excessive algae, and they prohibit discharges that cause degradation of water quality. We remanded this matter in February last year because the ALJs did not properly apply the Texas surface water quality standards in their proposed order. So the parties have had an opportunity to present new evidence and argument, and in particular, the applicant has had another opportunity to explain how the proposed phosphorus limit meets the Texas surface water quality standards. I believe the record still falls short of carrying that burden of proof. It does not prove that the total phosphorus limit of 0.15 milligrams per liter will meet the water quality standards. I think the evidence supports a much lower limit, again, confined to the circumstances of this particular record. And to that extent, I think that the ALJs may have gotten this right. But colleagues, before I go any further, let me pause and gather your thoughts. Commissioner Janeka.
I won't reiterate or repeat any of your points. I appreciate you stating your view and arrived at the same position in terms of the record supporting a lower limit.
Thank you, Commissioner Gonzalez.
Being the newest member to the commission, and just having the benefit of what's in the administrative record, I did not agree with the ALJ's recommendation to set a 0.015 effluent limit in the draft permit. I think based on the record and the slightly differing opinions by the protestants' expert witnesses, I believed that the maximum effluent limit necessary to protect existing uses and prevent degradation of the water quality in the receiving waters by more than a de minimis amount is 0.02 milligrams. And I also think that not only does the evidence support that it's protective of the receiving waters, but it also has the benefit of a detectable limit in the TCEQ approved National Environmental Laboratory Accreditation Program certified laboratory, and then is thus enforceable.
Yeah, thank you, Commissioner. And I think we landed in the same place on this. Let me explain a little bit about my view of the evidence. Based on the testimony of Drs. Stevenson and Ross, I come down the same place, 0.02 milligrams per liter. Dr. Stevenson testified that a discharge of no more than that amount during low flow periods will support recreational uses by preventing excessive amounts of algal growth and would not reduce aquatic life uses or aesthetic conditions in the river. Dr. Ross testified that a total phosphorus limit of no more than 0.02 milligrams per liter would be protective of the uses of the river by maintaining the same water quality conditions that are occurring upstream of the city's outfall. The ALJs based their proposed limit of 0.015 milligrams per liter on testimony by Dr. King, indicating that 0.015 is necessary to maintain natural conditions. The Texas surface water quality standards do not require maintenance of natural or background conditions. The standards prohibit degradation, which is a defined term, meaning lowering of water quality by more than a de minimis extent. I do not see evidence that a limit of 0.02 milligrams per liter would lower water quality by more than a de minimis extent. Commissioner Gonzalez, as you noted, Dr. King's work was based on a lab that is not certified. No disrespect to Baylor's lab. I'm sure it's an outstanding lab. It just is not certified through the National Environmental Laboratory Accreditation Program. Also note that neither the Texas surface water quality standards nor the implementing procedures recognize the notion of a tipping point. So those are my observations on the phosphorus limit. And what I might propose is that I'll circulate a revised order to make the necessary changes, and those will show amendments to findings of fact 86, 89, 112 through 115, and to conclusion of law 27 and ordering provision 1. It will show new findings of fact 89A, 107A, 111A, and 111B, new conclusion of law 14A, and the deletion of finding of fact 109. There are some other items on the order that I think need to be addressed and cleaned up, but if we want to pause here and talk more about phosphorus, we can do that, or we can do that at another point.
I'll only state that I'm in agreement on all the points you've highlighted down the board.
Okay, moving on to the other issues. Let's begin with nuisance. No,
Chairman, since we circulated that motion, do you, or your proposed order, would you like me to give a copy to the clerk?
yes. Yes, thank you. I'm going to continue my thoughts though, because this proposed order that's being circulated reflects changes that I think are appropriate in response to some other issues, not the phosphorus issue. So as to nuisance, the facility complies with the odor, and I'm talking about the facility now, complies with the odor abatement requirements at section 309.13E. But odor from decaying algae is an issue. And so I would make that clarification at finding of fact 123. Concerning the operator license classification, the nutrient sampling plan, and posting of the city's monitoring information on a public website, I refer to and incorporate the discussion from our February 8th, 2023 agenda. And just to summarize that, a Class B license is sufficient. I would require the nutrient sampling plan, and I would encourage but not require the city to post its monitoring information. And these determinations are reflected in the proposed order by amendments to finding of fact 140, conclusion of law 1, and ordering provision 1, as well as in the deletion of finding of fact 143 and conclusion of law 23. I would also add finding of fact 37A regarding the pre-hearing conference held after the remand of this matter, as the ALJs recommended the addition of that fact in their letter replying to exceptions, letter dated January 22, 2024. You'll also notice in the order other non-substantive changes, such as changing findings of fact 121 and 133 to new conclusions of law 15A and 22A, a clarification to ordering provision 3 that we adopt the executive director's response to comments to the extent consistent with the commission's order, as well as other corrections to typographical errors. So colleagues, I'm glad to entertain more discussion now, but it might be more productive for us to take a short recess and then come back and discuss on the other side. Okay. Why don't we take a 10-minute recess? Time is 1:59, so we'll reconvene at, let's call it 2:10, and we'll continue the item then. We are in recess at now 2 o'clock. I'll ask folks to please take their seats. So the time is 2:10. We're back in session after a 10-minute recess. Commissioner Janetka, what do you make of this?
I've reviewed the draft you circulated, and I'm comfortable moving forward today.
Commissioner Gonzalez?
Same.
Okay. I'll present a motion in just a minute. I do want to share one final observation, and that is to acknowledge that this phosphorus limit is challenging, and that is an understatement. We have an existing facility serving an existing and growing population. There's not a treatment technology that can be readily deployed to meet this limit. We are not going to have compliance overnight. In fact, we're very likely to have a significant period of non-compliance. We expect the city not to be in compliance immediately, but to pursue compliance with all due speed, and TCEQ staff is here to assist the city in that effort. And if there's nothing else, I will go ahead and offer the motion, colleagues, that we adopt the ALJ's proposed order as revised by the proposal that I have circulated today, that we issue TPDES permit number WQ00144770001 to the City of Liberty Hill as modified by the Commission in the proposed order I have circulated today, and adopt the Executive Director's response to comments to the extent it does not conflict with the Commission's final order.
I second the motion.
The motion has been made and seconded. All those in favor say aye. Aye. The motion carries. Ms. Smith?
I will call the next item, but I will give folks a moment if anybody's leaving or we've got staff coming back into the room, give everyone a chance to move.
It's possible that we won't have anybody else at the podium. I'm going to ask folks to please take their conversations outside so we can get to the next item. Why don't you go ahead?
Item number 2 is the consideration of the application by the City of Corpus Christi for wastewater use permit, or excuse me, for water use permit number 13675. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we had several requests for hearing on this item. If it were indeed a wastewater permit, I would look at it differently. It's a water use permit. And I don't see that the requesters have presented requests that demonstrate a personal justiciable interest different from the general public. Some fail to show sufficient proximity. Some fail to identify any personal interest at all. The one that got my attention a little bit was Mr. Serna's request. He, more than anybody else, did identify some recreational interests with greater regularity and specificity than any of the others, but I understand from the record that he was that his own waterfront property is about 3 miles away, and that he was recreating a mile or 2 away from the intake. And since this is a water use permit asking for requests to divert water, he's not being really deprived of any water at his property. I'm not seeing it. So, but I'm happy to hear your thoughts, Commissioner Ginecca.
I appreciate you highlighting Mr. Serna. His request was the single one, and then the Ingleside on the Bay Coastal Watch Association, who made a request on his behalf, were the only two, therefore, that got in striking distance. And I take your point on the analysis of the impact and degree of impact as to a member of the public with his distance, the alleged activities, recreational activities, given that it is the water right. It might look differently if this were a discharge permit, an effluent permit, but this is a different question of impacts and inputs. And I think in that vein, I don't disagree with your analysis.
Thank you, Commissioner. And to be clear, I think I understood you to say, but I certainly agree that the request by Ingleside on the Bay Coastal Watch Association and Mr. Cerna travel together. I think either we deny both or grant both. But Commissioner Gonzalez, what are your thoughts?
I agree as well. I think that's a very good point that this is a water use right permit, not a discharge.
Okay, well, I'll go ahead and make a motion then that we deny all hearing requests and issue water use permit number 13675 to the city of Corpus Christi.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the consideration of the petition filed by Theon Ranches LP and Daniel and Catherine Voss for the creation of Theon Ranches Municipal Utility District Number 3. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, we have a single request on this item by Williamson County. The proposed MUD is located within the county, and the county asserts its interest in and statutory authority over numerous issues relevant to the proposed MUD, including emergency management, fire and development codes, as well as roads, bridges, and other infrastructure. The county has clearly articulated a personal justiciable interest different from the general public, so I would grant its request.
I agree.
I agree.
Ready for a motion?
This is item 3.
Yes.
Thank you. I move that we grant the hearing request of Williamson County, refer the matter to SOA for a contested case hearing on the petition, and refer the matter to the Commission's alternative dispute resolution program concurrently with the SOA preliminary hearing scheduling process.
A second?
Motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 4 is the consideration of gifts and donations of $500 or more in value given to the TCEQ. Sorry. Submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. And the executive director's staff is here to present this item.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yen Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. I have none. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Arthur, what say you?
Good morning, or I'm sorry, good afternoon, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC recommends approval of the resolution acknowledging acceptance of gifts and donations as presented by the ED.
Thank you. I do too. Certainly appreciate our donors for helping our mission.
Indeed.
I move that we approve issuance of the resolution acknowledging the executive director's acceptance of the gifts and donations contained in the TCEQ interoffice memorandum to the commissioners dated March 8th, 2024, docket number 2024-0128-MIS.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next items.
That takes us to our enforcement docket, which are items 5 through 16, and the executive director are here to present these matters.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Michael Parrish of the Enforcement Division. And with me today are Melissa Cordell, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 5 through 16. The total assessed administrative penalties are $228,399, with $37,281 deferred, $75,318 applied towards supplemental environmental projects, and $115,800 to general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Mr. Parrish. I have none. Colleagues, any questions? Seeing none, has anybody signed in to speak?
No one signed in today.
Mr. Arthur, back to you.
OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. I do too, colleagues. I'm ready for a motion.
I move that we adopt items 5 through 16 as recommended today by the Executive Director.
Second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, please call the next item.
Item number 17 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this matter.
Good afternoon.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Craig Pritzloff of the Office of Compliance and Enforcement and Gitanjali Yadav of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2024 through January. There were 267 effective administrative orders issued, and of those, 53 contained supplemental environmental projects. These orders assessed a total of $5,764,329 with a payable amount of $2,394,210. $2,888,702 are to be applied towards supplemental environmental projects. 5,646 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 730 enforcement action referrals have been received. There are 2,818 pending administrative orders with 1,586 cases that are on the backlog. 172 cases are pending at the Attorney General's office for representation in district court, and 4 judgments have been issued. 1,788 cases are being tracked for compliance. We are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Any questions, colleagues?
No, thank you.
Seeing none, has anybody signed in to speak?
No one has signed in.
Mr. Arthur?
OPIC has no comment except to say that we appreciate the report.
I also appreciate the report, and colleagues, there's no action necessary on this item. So Ms. Smith, I'll ask you to please call the next items.
I will just give staff a moment to arrive in the hallway before I call this caption. So that takes us to items 18 through 23, which are quadrennial rule reviews for 30 TAC chapters 7, 70, 210, 285, 294, and 309. And the executive director staff is here to present these matters.
Good afternoon, Ms. Rico.
Good afternoon, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Gwen Rico with the General Law Division. Pending before you are items 18 through 23, the adopted rule reviews of 30 Texas Administrative Code Chapter 7, Memoranda of Understanding, Chapter 70, Enforcement, Chapter 210, Use of Reclaimed Water, Chapter 285, On-Site Sewage Facilities, Chapter 294, Priority Groundwater Management Areas, and Chapter 309, Domestic Wastewater Effluent Limitation and Plant Siting. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice for the review of Chapter 309 was published in the August 25th, 2023 issue of the Texas Register. The notice for the review of Chapter 7 was published in the September 8th, 2023 issue of the Texas Register. And the notices for the reviews for Chapters 70, 210, 285, and 294 were published in the September 22nd, 2023 issue of the Texas Register, all with 30-day comment periods. No comments were received for these rule reviews. Based on the review of these chapters, the executive director has determined that the reasons for the rules in Chapters 7, 70, 210, 285, 294, and 309 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapter 7, 70, 210, 285, 294, and 309. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and staff attorneys assigned to these chapters are available to answer any questions.
Thank you, Ms. Rico. I have none. Any questions, colleagues? Seeing none. Ms. Smith, has anybody signed in to speak?
No one has signed in.
Mr. Arthur.
With the understanding that outdated references in Chapter 7 will be addressed in future rulemaking, OPIC agrees that the reasons for initially adopting the Chapter 7, 70, 210, 285, 294, and 309 rules continue to exist, and we support readoption of the rules in each of these chapters.
Thank you, Mr. Arthur. Colleagues, I'm ready to readopt.
I move that we adopt the rule reviews and readopt the rules in 30 Texas Administrative Code, Chapter 7, 70, 210, 285, 294, and 309 without amendment as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye. Aye. Motion carries. Ms. Smith, please call the next items.
Items 24 through 27 are for our closed session, and the commission will not be meeting in closed session today.
The time is 2:28 p.m. We are adjourned. Nice work, guys.